Conversing is produced and distributed in partnership with Comment Magazine and Fuller Seminary. I'm Mark Labberton. Welcome to Conversing. Anytime I have the opportunity to have Yuval Levin as a guest on Conversing, I'm just excited and delighted to be able to do so. That's the gift that we have today. The reason that I particularly wanted to have Yuval as a guest right now is that we just come to the close of the 2025-2026 session of the Supreme Court of the United States. That's always a significant time in June when we finish out the rulings of the Supreme Court. As I see it, the Supreme Court is one of the three branches of government that may be the most functional right now, making its rulings all the more important. And this particular session has been full of very important and controversial decisions. And I'm anxious for us together to grow as citizens and to keep educating ourselves and understanding and remembering how and why our government functions as it does, and in particular, what the role of the Supreme Court is, particularly in relationship to justice, as well as in relationship to morality and goodness more broadly. Yuval is the Director of Social, Cultural, and Constitutional Studies at the American Enterprise Institute in Washington, D.C., where he holds the Beth and Ravenel Curry Chair in Public Policy. He's the founder and editor of National Affairs. He is also senior editor of The New Atlantis, a contributing editor at National Review, and a contributing opinion writer at the New York Times. Yuval is many things, including being a man of deep Jewish faith, and a person who has served in government, and a person who cares about our society and our nation in its 250th year and every other year that I think he's been around for. He holds his MA and PhD from the Committee on Social Thought at the University of Chicago. Yuval, welcome back to Conversing. What a delight it is to have you again.
Thanks so much, Mark. It's great to be with you again.
You're really one of my favorite people, and I do have very special gratitude for who you are.
Well, same here. Thank you.
As a person of Jewish faith, as a person who thinks deeply about the Constitution and many, many other things. And so it's always with great humility that I feel we have these conversations, because I'm not in any way an equal conversation partner to you.
No, please.
Especially when it comes to these matters that we're going to be jumping into. But it's exactly why I want to talk to you, because I come as a thoughtful citizen, but certainly not as an expert. And as we've just come to the end of another session of the Supreme Court, I just feel like it's always helpful to come back to you. I've jokingly said I have you on speed dial when I have my panicky moments in relationship to the Supreme Court. So let's just jump in with some basics before we come to this past term, because I'm still very much a learner about how I think and understand the Constitution and the Supreme Court relates to broader questions of morality. So let's just start with some of the big questions that I realize are deserving of whole books and probably multi-volume books. But in this case, we're just going to distill into some helpful kernels, I'm sure. Could you just start by describing how you understand the relationship between morality and law, and then between morality and the U.S. Constitution, and then morality and the Supreme Court? Those are the three things. Again, all of them are gigantic, I realize.
Yeah.
So jump in.
Well, thank you, Mark. First of all, thank you. I always love talking with you, and this is the reason why, because you ask the big questions and in a way that opens up the right sorts of conversations, and so I'm enormously grateful for it. Obviously, this is an enormous question, and I do think that there is a way in which the purpose of law in any society is to embody a moral framework in practice. And in a democratic society, That moral framework is ultimately established by the people's representatives through duly enacted laws that are brought into being by majority votes in a majoritarian legislature, affirmed by an elected president, and then applied by an appointed court. But there is also a way, and it is a very morally freighted fact that the institutions work this way, that the court is expected to operate in a somewhat counter-majoritarian way. The American system of government, very much for moral reasons, is expected to be both majoritarian and counter-majoritarian. The moral premise of our system of government is rooted in the conviction that we are all created equal. A conviction very deeply rooted in the Western moral tradition and in Christianity and Judaism. And the fact that we're all created equal has really two competing political implications, practical implications. On the one hand, if we're all created equal, then we need to be governed by majority rule in some way. Because if we're equal, then no one has natural authority over anybody else. We can only really make decisions by vote. We're all equal as voters, and ultimately the majority decides. At the same time, if we're all created equal, then we all have some basic rights, whether we are in the majority or in the minority. And those rights have to be protected by government in order to be legitimate. And this, too, the Declaration of Independence says very plainly, in order to be legitimate, the government has to protect our rights. And that means that our government is entrusted to simultaneously vindicate majority rule and protect minority rights. This is very hard to do. Obviously, those two goals are in tension with each other. And the American system does it by creating competing power centers that pursue these goals at the same time and that conflict with each other on purpose. The Congress is a majoritarian institution. The House, in particular, is a majoritarian institution. It is directly elected by the people, and it operates on simple majority votes. The Senate is just a little less so. The president is at a somewhat further remove because of the way he is elected, but still, these are majoritarian elected institutions. The courts are intentionally put at some distance from majority power. They are appointed by elected presidents. They are confirmed by an elected Senate. But once they're in office, justices of the Supreme Court cannot be removed except for really very gross violations of their oaths. They can be impeached by Congress, but it's never happened. A Supreme Court justice, well, you could say it's happened one time where there was a resignation before an impeachment would have happened. It's very hard to do. The salary of Supreme Court justices cannot be changed while they are in office. They serve lifetime tenure. And the reason for that is so that they are independent enough of majority power that they can protect minority rights and follow the law rather than the temporary whims of majorities. All of that entire framework, is profoundly morally freighted. It is what it is for moral reasons. And so in that sense, the law and the structure of the Constitution are very deeply rooted in a set of moral convictions. But that said, this also means that the role of the judge in our system has to be understood separately from simply the pursuit of the moral good. We incline to think about a judge like King Solomon. There's a question before him. He pursues the good and moral and just answer, and he finds a way to it. But in our kind of system, and in modern democratic systems in general, the role of the judge is much more constrained than that. It is limited because the judge is not answerable to majority rule. And so a judge has counter-majoritarian power, which has to be restrained because it's a lot of power. Once you're in office, you serve for life and you can get away with anything. And so the role they have has to be constrained. And the role of the judge in the American system is to apply the law, not to find the moral answer per se. We hope the law does that, though it doesn't always, and we know it. The role of the judge is to apply the law and the Constitution. to say, what does the law say? What does the Constitution say, rather than what is the moral answer? And that means that a good judge in the American system will at times, and maybe many times, end up advancing decisions and opinions that do not land as a practical matter where he or she would like, but that nonetheless are required by the law. I think American judges are actually pretty good at this, and I would say that in the current Supreme Court, everybody, all 9 of them, pretty regularly land in places that would not be where they would want to land as a citizen, that are not where they wish things ended up, but are where they think the law requires them to be. And to my mind, that's morally freighted too. That's an expectation we have of judges that involves a great deal of self-restraint, because our system ultimately has to balance majority rule and minority rights. That's how I think about the relation of these things.
That's extremely helpful. So when it seems, as it often does to people across the political spectrum, because it's not obviously something that's the privilege of one part and not the other part, there's many times when individual citizens or collections of citizens believe that the court has ruled wrongly, that it's both wrong in its interpretation of the Constitution, but secondly, it has done wrong in its ruling. It actually becomes a perpetrator of what is thought to be unjust. And that opinion, and those opinions, of course, happen all the time. So I'm curious then, in those moments, is the unspoken but presumed structure of our government such that then the citizen says, that's wrong. The court, I believe, did the wrong thing in making a certain decision. And I will develop reasons and rationales and so forth for understanding why I think a different view should have been taken, both on the grounds of what do I think the Constitution is trying to say, but secondly, on the grounds of one's own moral conviction about what kind of decision should have been made. So when that collision happens, just tell me where where you go in such moments, and what would you say to the average citizen who then is offended, hurt, injured, damaged by the decisions of the court?
Yeah, it's a very important question, and I think that kind of moment can send us in a variety of directions. It depends a little bit on what the court has said. If the court's interpreting a statute, a law, and interprets it in a way that seems unjust, then we have some recourse. We can change the law. And that does happen. There are circumstances where the court makes decisions and then Congress responds by changing the law. Now, we're kind of out of the habit of expecting this because Congress has a lot of trouble doing anything now. And so we don't really think this way, but there are actually a lot of examples of this. The history of religious freedom law in particular offers us a number of examples. There's a good one from the 1990s where the Smith decision, which was authored by a number of conservative justices, including Justice Scalia in that majority, seemed to many people to constrain religious liberty too much. And the Congress responded by writing a new law, the Religious Freedom Restoration Act, in direct response to the Smith decision, which said, well, okay, now the law is not that. And there was a large majority for it in Congress, and President Clinton ultimately signed it. I don't think he loved it, but he could see the case. And they changed the situation. Then the court had to say, well, okay, that now there's a new law. We've seen that happen a fair bit. It's harder to do when the court is interpreting the Constitution, because obviously amending the Constitution is very difficult. There have been instances when amendments have been ratified in response to court decisions. Maybe the most sort of direct and mundane one has to do with the 16th Amendment, which allows Congress to create an income tax. The Supreme Court had said that the Constitution as written does not allow for an income tax. And so Congress sent the states a constitutional amendment allowing for an income tax. They ratified it. It's in the Constitution, and we have an income tax. Less directly, but I think much more importantly, the post-Civil War amendments, and especially the 14th Amendment, were a direct response to a series of court decisions before the Civil War that said black Americans are not citizens in the United States. And after the war, Congress sent the states an amendment, the 14th Amendment, which said all persons born or naturalized in the United States are citizens in the United States, specifically and directly answering the court saying black Americans are citizens, full citizens of the United States. Obviously a controversial amendment. It had to be forced on the South, but it was in direct response to the court's, in my view, wrong, by the way, but nonetheless, the court's reading of the Constitution as it was written. The trouble comes most profoundly when the court seems to us to read the Constitution incorrectly, but there's not much we can do about it. I think this was the experience of the pro-life movement for a 50-year period after Roe v. Wade, when the pro-life movement directed itself to changing the makeup of the court in order to change the court's interpretation of whether the law could prohibit or restrict abortion or not. And it succeeded. Over a very long stretch of time, the court came to be populated by a majority that disagreed with Roe and overturned it. That's a way of thinking about how to address what seems like a miscarriage of justice by changing laws, by changing judges. There are many instances when we just don't really have that option. And when the court makes a decision that we believe is wrong as a matter of law or morality, and then there's just not much we can do about it. The experience of being a minority in a democratic society is challenging. It is difficult. I think in part our system tries to mitigate that some by allowing us to sometimes be in the majority and sometimes in the minority. And hopefully all American citizens have some experience of being in the democratic majority so that they can get their way. And that helps us to live with those moments when we're in the minority and we don't get our way. But there's nothing easy about it, and it's especially difficult when it is the court, and when the court says, no, the Constitution advances a vision that seems to me unjust or immoral. That puts any citizen in a very difficult position, and there's not an easy way to address it.
So, Yuval, would that be your way of understanding, for example, the politics around creating a majority court that moves either left or right politically, that we should handle it as a seasonal thing? Or is that a sign of something structurally wrong about how the court gets constituted?
Well, I think that what we think of as ideological differences among justices on the Supreme Court are probably better understood as interpretive differences in their view of the Constitution and of the role of the judge. And a lot of those now are defined in relation to the idea of originalism. Originalism arose as a way to restrict judicial power after many decades in which the Supreme Court had exercised an enormous amount of power to essentially redirect the meaning of the American Constitution, creating new rights or reading them into the Constitution in various ways. They drew a lot of resistance and reaction, and among the responses they drew was an idea of the role of the judge that said, in a democracy, judges have to just read the text. Mm-hmm. Any other way for a judge to be is illegitimate and undemocratic because it's just the will of the judge. Anything that isn't what does the law say is some form of what does this judge think, and no one should have that much power. That's the beginning of originalism. It began really as judicial restraint. It's evolved a lot since then. It is not simply judicial restraint now, but it began as a way of trying to ground the power of the judge in the words of the law. And a lot of our kind of judicial ideology debates now are about originalism, or whether originalism is sufficient as a description of what judges do. What does originalism require? I think if you look at the current court, it is basically divided into originalists and counter-originalists. Some of the Democratic appointed judges are originalists who argue that the right gets the Constitution itself wrong. I think Justice Kagan makes a very serious case along these lines. Some of them think originalism itself is the wrong way to think about the role of the judge. Justice Jackson is an example of this, the newest member of the court. among those appointed by Republicans, you see different forms of originalism or textualism. Some of them incline more to think about the history involved in the words of the text. Some of them incline to simply read the words and ask, what does this word mean? But today's court is really organized around the question of originalism. That's relatively new. That idea really emerges about 50 years ago, which in the stretch of American constitutional history is relatively new, and it became dominant really only in the 21st century.
Mm-hmm. Well, you and I both take the text of the Bible very seriously and are careful readers of the Scriptures and understand what originalism means in biblical interpretation, where you're attempting to somehow, now in this case, millennia removed from the writings of many of these texts, to try to understand through the grammar, through the history, through the geography, through the politics, through the philosophies that are current in the Bible and outside the Bible, how it is that we can give a, quote, faithful reading of the Bible, which then splinters into varieties of camps. For example, you have a faithful liberal reading of the Bible, and you have a faithful fundamentalist reading of the Bible, and you have a faithful evangelical reading of the Bible, et cetera, in Christian terms. And each of them would claim originalism in their own way, but each of them would also come out in wildly different interpretations. Just respond to that as a literary fact. I mean, well-intended or even highly driven readers with specific objectives certainly come out in different places. So,
yeah, I mean, look, you see some of this in judicial originalism. I would say there are important differences, obviously.
Yes.
No one claims that the law is divine.
Right.
And so unerring, and that matters. Everybody understands that we're looking at legislative language created by human beings, and this points in different directions. On the one hand, there's a lot more evidence to work with. We know what the debates around the 14th Amendment were about. They were public debates. There are transcripts. We don't have that when it comes to the writing of the book of Joshua.
Right.
But on the other hand, there is because originalism emerges as a mode of constraint on legal power, there's a kind of constraint that says, just read the words and ask what they meant at the time. And that's it. You're not looking for the purpose. You're not looking for legislative intent. It's not original intent for legal originalists. It's original meaning. And in a sense, for a lot of originalists, constraint is the point. Mm-hmm. And the goal is to enable the judge to vindicate the law, to allow the law to be dominant. There's also one other difference in that there's a layering here where the Constitution matters more than statutes. And so constitutional originalism is particularly important. That ultimately has to prevail. The Constitution is much harder to revise, and it is taken to be the supreme law, as it says it is, the supreme law of the land. And that means that if a statute is found to contradict the Constitution, then the Constitution wins that argument.
Right.
That means that the interpretation of that very short document, and in some ways rather vague document, comes to be extremely important. And a lot of the work of judicial interpretation is about trying to apply very vague kind of glittering generalities to very concrete circumstances. Right? The Constitution says that the government is not allowed to engage in an unreasonable search or seizure. Well, what does that mean now? What does that mean when the police can use LiDAR to look through the walls of your house? Is that unreasonable search and seizure? James Madison did not provide an answer to that question.
Right.
And that means that there is still always room for interpretation that has to rely on the judgment of the individual judge. And the text will not provide the answer. And some of the hardest cases that the courts confront now are about those kinds of questions. What does this term from the 18th century or the 19th century mean in this 21st century circumstance? And you find avowed originalists on different sides of these questions. There's no simple answer that just emerges from however faithful a reading of the text you might attempt.
How then, in light of that, does the politics of the moment play into all of this? Obviously, we're aware that the appointment of Supreme Court justices is it seems to me, a very highly charged political event. Yeah. And at a time when Congress, as we've spoken about on this program before, at a time when Congress is so astoundingly and agonizingly weak, I'm assuming that it makes both the role of the court all that much more important. But on the other hand, it also problematizes the court in a way that it wouldn't be if you felt you had a really vigorous Congress that was doing its job.
Well, that's certainly true. I think that we're in a moment when the court is exceptionally important because Congress is unusually absent from key political disputes. And that means that a lot of the questions the court has to resolve are questions of executive power and separation of powers. It's worth saying that that's actually pretty unusual, that in some ways those questions of separation of powers are the questions that most occupied the authors of the Constitution. If you read the Federalist Papers, a lot of them are about these questions, and they've become really unusually relevant in our time. This is a very good time to get to know the Federalist Papers. For most of our history, the most divisive questions that confronted the Supreme Court were actually questions of personal rights. Those are still important. They still arise in every Supreme Court session. There were several important cases along those lines in this session. But now the most divisive or significant cases before the court very often are about the separation of powers, the limits of executive power, various administrative law questions, who can the president hire and fire, what kind of powers does he have and does he not have. I would say there's no doubt that the appointment of Supreme Court justices is an extremely politically freighted event. It matters a lot because the court has a lot of power and, in a sense, has the final say over very important constitutional questions. All of our recent presidents, including, somewhat to my surprise, President Trump, have allowed the court to have the final say. When it's made a decision they don't like, they deal with it. That's good. That's very important. But it does mean that naming justices matters a huge amount. But I would say it's political in a particular way, which is we decide on a few issues that we take to be decisive, and then we judge potential judicial appointments based on their views of those issues. And on a lot of other issues, we aren't really thinking through what kind of court we're putting in place. And so for judicial conservatives, the questions often have been questions of where does this justice stand on some questions of personal rights. Abortion was essential, especially before Dobbs. And the judges that have been appointed that way are all over the map on other issues. On freedom of speech, Justice Alito is in a very different place from Justice Gorsuch. We've found in this last session of the court that two justices who might seem to be sort of demographically and biographically almost identical, Justice Kavanaugh and Justice Gorsuch. The two of them are the same age. They grew up in the same place. They literally went to the same high school and had the same history teacher. Their mothers knew each other. And they were formed in the same way and appointed by the same president. They agreed with each other 52% of the time in this last term of the Supreme Court. They're both conservative justices, and on some of the most divisive issues, they are on the same side. But they have very, very different ideas about administrative law, about the role of government, about executive power. They're quite different, as it turns out. I don't think President Trump knew that when he appointed them. I don't think many other people knew that when he appointed them. And it turns out that when you assess these people on the basis of just one or two issues that matter most, you actually end up with a pretty peculiar range on the host of issues that a judge ultimately has to deal with.
Right, right. This is all extremely helpful and fascinating, Yuval. There's another thing that I've never heard really defined, but that feels very pertinent just to round out this part of the conversation. And that is that I've often heard in historical analyses of the movements of the court and why it made decisions of a certain kind and so forth, that it has to do something with, I don't know what the right language would be, but something about the court's measurement of what is the pleasure of the nation or the state of the nation. First of all, correct my obscure language, trying to even name it. And then tell us how that plays into the judgment of the court.
Well, I would say it's really implicit now. The court always has to work with some sensitivity for what the country will tolerate. And, in their everyday work, judges don't talk this way, and I don't think that they would be eager to acknowledge that they're doing that. But there are limits on what they can do, because ultimately the power of the court is a function of the perception of its legitimacy.
Right.
The presidents do let it have the last word. Congress lets it have the last word. They don't really have to. I mean, I think legally they do, but practically they don't. If a president ignored a court decision, it's actually not at all clear exactly what would happen. We don't want to find out, but the reason the court has this kind of legitimacy and therefore authority has to do with its willingness to operate within some set of boundaries of American political culture. Courts have certainly pushed those boundaries sometimes in the past. They've done it carefully. They have done their best at key moments to do it unanimously. You think, for example, about Brown v. Board, which could have been a much more assertive decision, but the Chief Justice of that moment really wanted it to be a unanimous decision. And I think he was right. It made a difference that it was unanimous. We've seen that a fair amount in the Roberts Court. Chief Justice Roberts really wants unanimous decisions, and he gets a lot of them. 45% of the decisions in this last term were unanimous.
Wow.
We don't think about the court that way, but it actually operates that way quite a bit. And there, too, the Chief Justice bends over backwards to create space for unanimous decisions, especially by constraining their implications, by deciding things narrowly rather than broadly. A lot of that is a kind of judicial statesmanship or judicial politics. The court has to play that game to some extent, but there have to be limits to it, too. And at the end of the day, the court does have to decide what the law means in very controversial circumstances, and it isn't always possible to do that in a way that's not divisive. And so the court is divisive. It has always been divisive in American life.
Right. I had a professor who would sometimes come in and start his class with some musings philosophically about the nature of reality, and then he would tap his little notebook that he had in his hand and say, "Students, now that the universe is in order, class can begin." And so you've just helped put the court a bit in order for us, which is terrific. So now let's actually turn to the questions of your evaluation of this particular term that's just ended, and do so as broadly or specifically as you want to, and then I'll ask some follow-up questions.
Well, I think this was a very important and consequential term of the court. It mattered especially, as I suggested before, in terms of administrative law, presidential power. There were a lot of important questions before the court that had to do with what I frankly think are excesses of presidential power over the past year, which ended up as cases before the court. And I think the Supreme Court is charting for itself a coherent but complicated kind of constitutional teaching on the limits of presidential power. The court is saying to presidents, you are in charge of the executive branch, but the executive branch is not in charge of the American government. And sometimes those can seem like contradictory assertions.
Please unpack that for us.
Yeah, the president, there are limits, and there have been for a long time in the American system, on the president's control of the executive branch itself. There are agencies that the president doesn't really fully control, that we've thought about as independent regulatory agencies. They're often governed by boards that are bipartisan, and the president can't simply remove their members. The Roberts Court, for a long time now, for more than a decade, has been gradually reducing the independence of these agencies on the premise that in our system there are only three branches of government. Everybody has to be accountable to one of them, and these agencies don't seem to be accountable to any of them. They're not congressional agencies. The work they do is executive, and yet the president can't fire people. They don't really work for him. He can't tell them what to do. This term, the court just all out said, this is over. This independence has been guaranteed by the Supreme Court since the 1930s in a case called Humphrey's Executor. And this year, in one of the cases announced at the end of the term, Trump v. Slaughter, the court formally overturned Humphrey's executor and essentially said these so-called independent agencies, actually, they just work for the president. And their members will be appointed in the way in which presidential appointments work, which means the Senate has a role. These are Senate-confirmed positions. But the president can fire those people without the Senate's involvement and without the need to prove some complicated kind of legal wrongdoing. They work for him. And if that's not working for him, then he can fire them, like he can fire a cabinet member or other Senate-confirmed people. That's a big change in how the American administrative state works. And, the court has been getting here for a long time, but the president, in that sense, has more power than our presidents have had in a long time. At the same time, though, the court has gone out of its way to say to the president, your powers are the executive powers that exist in the Constitution. You cannot exercise Congress's powers in its place. And there were a number of cases in this term, very important cases, I think more important than the removal power cases, where the court said to President Trump no on issues that he cares about a lot. The tariffs case, which to my mind was probably the most important case of this term, involved a judicial constraint on presidential power that was more direct and strict than we've seen in a very long time. And in that case, the court simply said to the president, your powers do not extend here, and you cannot exercise this power at all. It was a peculiar kind of majority. The case was a 6-3 case, but not the usual 6-3. The minority, the dissenters were Justice Alito and Thomas and Kavanaugh. And the court constrained presidential power in a very important way. They also constrained presidential power over immigration enforcement, which matters to the president at least as much as tariffs. They told him he can't have the National Guard in Illinois without the approval of the governor, a very important decision. And they constrained presidential power at the very end of the term in the birthright citizenship case, where again, a peculiar majority of the court, in that case the dissenters were Thomas, Alito, and Gorsuch, said to the president, you don't have the power to change how we apply the 14th Amendment. Maybe Congress can do it. Justice Kavanaugh thought so, and he was part of the court's majority in this case, but thought that maybe by statute you could change this, but certainly the president cannot do this. I think the birthright citizenship decision is very important. It's broader than it's kind of gotten credit for, on the question of whether people who reside in the country illegally and have a child, whether that child is a citizen. The court was actually 9-0. The difference between the dissenters and the majority was about temporary visitors to the United States, which is a very narrow subject. Mm-hmm. Broadly speaking, they affirmed birthright citizenship, and this is a very important case. And again, they constrain the president. I would say that the rule of thumb for me after this term is that if you come to this court with a pre-Trump conservative legal argument, you're going to win. If you come to this court with a Trumpy legal argument, you're going to lose. And that's an extraordinary thing, given that 3 members of this court were appointed by President Trump. But the court is now acting to constrain President Trump in all of the areas where he is distinct from our prior presidents in his exercises of executive power. And I think we experienced the high water mark of executive power about a year ago, and it is now receding. That's extremely important. The other very important case in this term, which is not exactly of this sort, it is not an executive power case, was Louisiana v. Calais, which is the voting rights decision. There again, the court has been moving in this direction for a long time, but in a much clearer way basically said that Section 2 of the Voting Rights Act should not be understood to require states to draw majority-minority voting districts, basically to reflect the proportion of the population that is black by the number of districts drawn to make it likely that a black member of the House will be elected. The Voting Rights Act had been read that way for a long time, since the 1980s, and now will not be read that way. That will have a dramatic impact on redistricting, including mid-decade redistricting, which we're experiencing now. That also is a very important case. It was not surprising, I think, ultimately, because the court's been moving this way for a long time. But that was a more traditional kind of 6-3 decision where all of the Republican-appointed justices voted for this change, and the 3 Democratic-appointed justices voted against it. I think those are some of the most important cases.
Right.
It is important to see not all the cases are like this. As I said, about 45% of the cases this year were decided unanimously. And that's not a record, but it's pretty high. There are also there were a number of 8-1 cases, including on some very controversial issues, transgender issues and others. There were a number of 7-2 cases. Even the 6-3 cases, and I pointed to a couple of them, were not all Republican appointee versus Democratic appointee. So there's a lot of variety here, and all the justices are involved in majority opinions a lot now in the modern court. Justice Jackson is in the fewest majority opinions, but she was in the majority 67% of the time in this term. So this court does rule by consensus quite a bit, but the cases that divide it are very constitutionally significant cases.
It really has been an amazing session, and it's part of why I wanted to follow up, because using as an example, going back to what we were talking about at the beginning of the conversation, where I think the court makes decisions that are not, I don't have the expertise to say that they're not constitutional. I don't have the expertise to say that that it seems illegal, but I can say that from a moral point of view, anything that dismantles a sense of an acknowledgement of the social and political reality of racism in America is throwing down a gauntlet for someone like me, who believes that is still remains very actively daily the experience of not only Black Americans, but people of color across the country as a crisis every single day. So anything that dismantles a sense of gaining votes, gaining what I think is understood by many Black citizens and Black people that I know, is the sense of having lost ground that had been gained. Now, I know that you're supportive of that decision because we've talked about that privately, but I'd like you to articulate why. And then I'd like to understand, this is one of those places where, as I was suggesting, you come up against the decision and you say, now what do you do? So in light of the dismantling of the Voting Rights Act, what can be done that would be attempting to address the same moral injustice that exists in our society while doing it constitutionally? Yeah,
I mean, this is where the distinction that we drew at the beginning of our conversation about the role of the judge in our system really comes to matter.
Yes.
Because the question for the court was, what does the law say here?
Right.
And what does the Constitution say? And as a practical matter, the question was whether states are required under the Voting Rights Act and the 14th Amendment to essentially draw districts based on race, to explicitly use race as the reason to draw their House districts in a particular way. The Voting Rights Act as written is very unclear on this point. We're not talking about the original Voting Rights Act of 1965, but about the amendments to it in the 1980s, which are vague. I mean, there's just no way around it. And both the majority justices and the dissenters in this case acknowledged that. The question for the court was whether it is possible now to separate political gerrymandering by the majority party in the state for its own political goals, and racial gerrymandering. And what the majority opinion written by Justice Alito said was that in order to show that a map is drawn with racist intent, you'd have to show racist intent. Now, that's very hard to do. And no one's going to put on the record that they redrew the map in order to reduce the number of districts with black members or districts with black majorities. And it's made even more complicated by the fact that today there's just an extraordinary alignment between race and partisanship. Black voters vote for Democrats by 90% and more in most of the country, which means that if what you're trying to do in the South in particular, where white voters are very predominantly Republican and black voters are very predominantly Democrat, if you're just trying to gerrymander because you're a Republican and not because you're racist, and if you're trying to gerrymander because you're racist, well, the map is going to look the same. The result is going to be the same as a practical matter. The dissenters in this case, Justice Kagan in particular, who wrote the dissent, says, well, that means that we should restrain partisan gerrymandering. And the majority in this case says, well, that means we can't restrain race-based gerrymandering. They're saying the same thing, and they're saying the opposite thing at the same time. And the reason is black voters are Democratic voters now in the South. White voters are Republican voters. Not entirely, not altogether. There are 4 black Republican members of the House in the South. There are certainly many white Democrats in the South. But on the whole, that is the case. That was not the case at all in the South when the Voting Rights Act was written. Right? In 1965, white Democrats were the party of segregation. And there were many black Republicans in the South because the Democratic Party was the party of segregation in the South. That is not the case anymore. There are very, very few black Republican voters in the South. And that creates a situation that basically, if you read the Voting Rights Act to require black majority districts, then you're reading it to require Democratic districts. The court decided that that is not how the law can be applied, and that it's actually a violation of the 14th Amendment, which Justice Alito takes to require essentially race-blind politics in America, that our laws cannot be written one way for black citizens and another way for white citizens, whether to the advantage of black citizens or, of course, to the disadvantage of black citizens. I think that's correct. I don't love the outcome, but I think that's right. As a reading of the law and of the Constitution, it seems to me that the court majority is right about this. The trouble is, of course, that as a practical matter, that means that there will be some seats that are now held by black members of Congress that will be threatened by redistricting. And we see that already. There are 23 black-held seats in the South out of 55 total black-held seats in Congress, 59, I'm sorry. And at least 4 or 5 of those 22 seats now are going to be redistricted out of existence. That's a significant proportion. The difference it makes is a real difference. Now, I think part of the reason the majority landed where it did is because we're actually in the midst of a broader process of redistricting around the country, which doesn't really look that different in the South than it does in other places from a partisan perspective. We're seeing mid-decade redistricting, which is unusual, take place all over the country with an eye to partisan advantage. And that's also happening in the South. And so they're comfortable saying, this is about partisanship, it's not about race. Maybe partisanship is bad, but the court has no power to restrict it. And that is true. That is reasonably clear. Partisan gerrymandering is allowed by the Constitution, is conceived by the Constitution. So I think as a matter of law, this case is rightly decided. The problem is that it now creates a circumstance where black representation in the House will be diminished. It will still be, I think, roughly at the level, in the proportion of black Americans to the population of the United States, but nonetheless, there will be significantly fewer black members of the House after the next election cycle than there were in the last one. And I think that given our history and given the reality of racism in American life, that is a problem. It's just I don't think the court can solve that problem by pretending that the law and the Constitution say things they don't say. And so this just isn't an area where the court can reasonably rule differently, as I understand it.
So that's where Congress, in its better operational mode, could potentially respond. Not that that's going to happen currently, but it could potentially respond.
Yes.
If it was to respond, give me a sense of how you would imagine racial justice being more clearly established in the United States as a consequence than this mechanism, which has been a part of that process of trying to make racial realities in the U.S. more just.
So the Voting Rights Act has not been reauthorized in some time.
Yes.
And there are ways that it could be clarified, but I don't think that it would be right at this point to require some set number of black majority districts, even in the South. That's not because I don't think there's any racism left in the South or elsewhere. There is. But I don't think that we can compare our situation to the situation of black voters in the South in the 1960s and before. The Voting Rights Act has been a tremendous success. Black voter participation is now indistinguishable from white voter participation in the South, which is an amazing reality. I think that getting there had a lot to do with the Voting Rights Act. I don't think that staying there requires that there be set-aside districts by race. And I don't think set-aside districts by race are ultimately good for the civic health of American society. And so I would not favor reestablishing that requirement or somehow clarifying in a reauthorization of the Voting Rights Act that is required. And, I think in states where there are large Republican majorities, there are going to be largely Republican House delegations. There are a growing number of black Republicans, and that's good. It's good for Republicans, among other things. And I think there will be a growing number of black Republican members of the House in the South. There are other areas of the country that are increasingly Democratic. As the South is increasingly Republican. You see that more now in the Northeast. You see it more in the Mid-Atlantic states. And I think that change in representation will include changes in the racial makeup of the Congress. I would not solve this problem by reinstating the Voting Rights Act as it worked in the 1970s and 80s. I don't think that's the right solution in 21st century America.
And instead, it should be something that emerges out of this racial demographic change and the ways that over time there will be realignments that will diversify.
Yeah, and you would hope that over time we have less racial polarization in our partisan politics, and that more black voters feel comfortable voting for Republicans. That's up to the Republican Party. They have to make themselves more attractive to black voters. And look, if they want to win, they're going to need to do that. They're going to need to do it in Georgia, which is an essential swing state in our politics now. In Pennsylvania, in Michigan, there are a lot of black voters. Those voters don't feel like they can comfortably vote for Republicans, and that is the fault of the Republican Party. So that ultimately it's up to them to change that. It's in their interest to change that. I don't think it's going to happen magically, but I think the kinds of incentives they confront in our politics can drive them in that direction. And I don't think that explicitly racial gerrymandering is a good solution to that problem.
So that's where I don't understand why gerrymandering is legal at all. That just seems like the most harebrained idea I've ever heard of. And secondly, that the idea of allowing political gerrymandering around party gerrymandering makes sense either. Though it feels like both of those two things are just completely...
Yeah, absolutely. I mean, this is where the problem you always face when you think about political reform is compared to what? What's the alternative?
Right.
And somehow the states have to decide how their apportioned number of members are selected. Who do they represent? The Constitution leaves that up to the states because there isn't any obvious way to solve that problem. The number of members each state gets is determined by its population, but beyond that, it's up to the state. And then the question is, how do you decide? And the answer that most states have come up with is the decision ought to be made by elected officials at the state level because anybody else making them wouldn't have the legitimacy to make this important a choice. Now, there are some states that have assigned that role to nonpartisan commissions. It's how it's done in the state of Maryland, where I live. That still has to be approved by the state legislature, but the legislature votes up or down on a map. Maybe that's better. Maybe it's not. It's very controversial in those states, too. There isn't a way to do this that doesn't somehow involve Democratic majorities deciding on the state's map. And the fact that they can decide that way means that some form of gerrymandering is going to happen. They're going to decide that question based on how they can maximize the majority party's representation one way or another. And so I think there's a case to make that it's better to make it explicit and at least let people see that that's what's happening. But it has tremendous problems, obviously, and it leads to a lot of underrepresentation. That's the case with black voters in the South. They're about 30% of voters in the South and, more like 20% of members of Congress. It's even more extreme in other ways. In New England, Donald Trump won about 35% of the vote in the last election. There are 0 Republican members of the House from New England. And that's because of gerrymandering, too. It happens to both parties. And the parties have gotten very good at it because you can now use technology, you can use software to gerrymander down to the level of the voter. You know what party people are registered to, and you can create districts with very, very fine lines to achieve the result you want. Obviously the downsides of that are enormous.
So what that ends up creating for me is just that deep skepticism that comes from an acknowledgement of the human heart that is always deceptive and self-deceptive especially, and prone to its own interests in a way that is not looking out for perhaps anything or anyone other than a person's own view. And that's true across the political spectrum. Of course, that's not the characteristics of the right or the left only. So what it creates for me is a sort of legal fiction that feels like we have a structure that doesn't then come back to the fundamental moral questions of what is good and what is true and what is just. It comes back to what is expedient and what is possible and how does power win. So I hear you, the depth of your arguments, and I do understand, I think, what you're also getting at in terms of the way that society changes these things is by being a better society. And that is not just the subject of Congress or of the executive branch or of the Supreme Court, but really of people's own individual and collective decision-making.
Yeah. And there is, it gets back to where we started in a sense, which is the very complicated charge we give to American government, which is to vindicate both majority rule and minority rights, means that there are places where that tension really comes to a head. And this is one of them. There isn't really another way to make these decisions than by majority rule, and yet it is essential that they be made in ways that protect minority rights. And ultimately, the way that our system is built to handle that contradiction is by dividing power and creating competing power centers, allowing decisions to be made by different kinds of majorities in different sorts of ways. That often works to balance different kinds of interests, but the areas where it has failed, and this is just a fact of American history, the areas where it has failed most are concentrated around questions of race. That has been true from the beginning. It is thankfully less true than it used to be, but it is still true. And I think we have to be uniquely sensitive to those questions for that reason.
Right. Yuval, thank you again for a very stimulating conversation and for the chance to get the insights that you have. And I'm just so appreciative of our friendship and appreciative of your time with us today. So thank you very, very much.
Thanks so much, Mark. Same here. I really appreciate you.
On this 250th year, I think we can both be grateful for our country and for its Constitution.
Absolutely.
Thanks again. Conversing is produced and distributed in partnership with Comment Magazine and Fuller Seminary. Peter Labberton is our engineer and editor. Evan Rosa is our producer. For more information about Comment Magazine, visit comment.org, where you can subscribe, read the current magazine issue, and browse their archive. Fuller Seminary is an evangelical, multi-denominational graduate institution committed to providing indispensable formational education for diverse Christian leaders everywhere. For information, visit fuller.edu. I'm your host, Mark Labberton. Thanks for listening with me.